When buying certain commodities for resale, the Defense Commissary Agency doesn't always have to use full and open competition. It can pick among suppliers after a simple request for information. But that doesn't mean there are no rules, as the agency found out in a protest. Haynes Boone procurement attorney Zach Prince joins us with the details. And this was a case of statute and FAR kind of not being in total agreement. And they ended up at GAO, which sided with the protester. So tell us what happened.
Sure, Tom. So this was a case that was brought by EKK Investments. They're a company that sells fresh fruits and vegetables. The Defense Commissary Agency was purchasing fruits and vegetables for resale in Korea, and they put out a request for information, or RFI, to about 6 sources to see who might be bidding. They had a bunch of questions. 4 of those 6 responded, but usually folks who know an RFI is not a solicitation, but the agency treated it like one, and they awarded to one entity and not to any of the others. And the protester only found out about this when it asked, hey, are you going to put this out for solicitation? And the agency 2 days later said, sorry, we actually already awarded it to your competitor.
So it sounded arbitrary and capricious under FAR rules, correct?
Yeah, I mean, what it really was is, in general, there's a requirement for full and open competition. That's the baseline. The government gets the best prices and gets the best items that it needs when it goes out to the marketplace and solicits competitors. But there are exceptions. When those exceptions are invoked, there are still rules. One of those rules is that the agency, generally speaking, has to issue what's called a J&A, or a justification and approval document, documenting the rationale for why they don't have to use full and open competition. One of the other rules is that even when they can limit competition, because there's a statute that gives them that authority, they still have to solicit offers from as many sources as practicable. The agency didn't do either of those things here.
Right. So then, in effect, they tried to play both sides of the street using a rule or a statute that allows them to buy name brand items without this competition necessarily. But they weren't buying brand name items. They were buying undifferentiated commodities.
Yeah, that's basically right. So the agency latched onto a fairly complicated statutory interpretation. And I'm not sure if they thought this was the case from the outset, or if they're just coming up with a post hoc justification for what they actually did. But there's 2 different statutes. One that says there's an exception for competition that's available for agencies that are purchasing commercial products, brand name commercial products, for authorized resale. And then there's another statute that specifically authorizes DoD to treat any commercial product that's for resale by commissary stores as though it was falling under that brand name commercial product resale exception. But they're not the same statute. And so there is an exception from the J&A requirement that applies specifically for the brand name commercial product exception. But that doesn't mean that anything else that's treated like a brand name commercial product falls under that exception too.
Right. Okay. So then review the grounds for the protest.
So the protest was basically just that. First, that was the complicated statutory issue, right? Was the agency actually required to issue a J&A? The GAO said, yes, they were required to issue the J&A, and they didn't. The real point of the protest, though, was the agency was required to go out and solicit offers from as many sources as practicable, and they just didn't do it. The agency's argument for why that didn't apply was much, much weaker. They really just said, well, Congress really intended that we should be exempt totally from any of these requirements about going out and getting sources, but they didn't say that anywhere. There's no statute that says that. There's not even legislative history that the agency pointed to that said, well, Congress means this. It's just they're trying to infer that Congress really wants to accept anything that's sold in the commissary stores from competition requirements. And it's just, that's not in the statute.
We are speaking with procurement attorney Zach Prince. He's a partner at Haynes Boone. And so what happened at GAO?
So GAO went through this analysis, and I thought their analysis was right on. It was good. They said the agency failed to comply with the statute and failed to comply with the FAR. And the agency says that, well, really, they did get as many sources, as many offers as was practicable, but they didn't get any offers, is the truth, because they didn't issue an RFP. They issued an RFI. And the RFI said this is not a solicitation. So nothing they got back was an offer. The agency spent 4 months doing this RFI process. They could have easily spent those 4 months doing a traditional procurement process. So any argument from the agency that it was impracticable to get offers sort of falls flat. So the GAO recommended that they cancel the BPA, and to the extent that they need to procure these fruits and vegetables, and I assume they do, they have to follow the FAR and the statutes.
Yeah, and so they told them, the GAO told the agency that you've got to start over. I mean, there was a remedy here.
Yeah, there was. And the agency could come back and they could say, well, we need it now. And so it's urgent, compelling, and document their justification for that and go out and buy anyway from a single source. They could do that. They could totally ignore GAO if they want to, because GAO doesn't issue decisions like a court does. They're not enforceable. But if the agency does, they're going to have to explain to Congress why they did that. And no one likes to do that. So I think they're going to go back out and they're going to, this time, solicit offers from more than one vendor. And hopefully they'll do it quickly, but they have to follow the process.
Yeah, the worst thing would be empty store shelves, and then you've failed your customers there if there's no fruits and vegetables, as you point out. And let's get to the bigger issue of RFI versus RFP, because traditionally, the big IDIQ contracts or the GWACs, say, that come from GSA, they start with an RFI pursuant to developing the RFP. Isn't that the usual use of an RFI? Is it fair to call it a form of market research even?
That's exactly what it is. Right? It's an RFI is going out and getting information for the agency to help them figure out what to buy and how to buy it. It's not a request for proposals or a request for quotes. It's not an RFP or an RFQ. It's a request for information. The agency did this very strangely because they called it an RFI. It says in it, this is not a solicitation. But then they went ahead and they took the RFI responses and they graded them like you would with proposals. It doesn't make any sense. And I'm not sure what the agency was thinking.
It's hard to know what would be an RFI for fruits and vegetables. I guess maybe frequency of delivery, what is standard. But it sounds like the answers they got were of a commercial nature and not of here's how the industry works or here's what is generally a capability you should solicit.
Right. This is what we could do, and we would probably respond to a solicitation, and this is generally what we think we'd be able to do here. It's not too different from what might end up in a offer's proposal, but it isn't a proposal at this point.
Right. So is it what should, going forward, based on this case, when they receive an RFI, what should a contractor do? Should they keep it strictly industry information, their view of how things work, or should you also put in, if we got this type of work, here's how we would do it?
I mean, really, I think they should do the same thing they did here. You respond to an RFI the way that an RFI asks you to respond. It says, please provide us this information about your capabilities and your interests in submitting an offer. And that's how offers responded, it seems. It's just that the agency got confused about what an RFI is versus an RFP. Some of that might just be because of strained agency resources at the moment, although this did happen last year, so maybe that's being too kind.
Yeah, sounds kind of like a basic error they made.
Yeah, it was a pretty basic error. I mean, they're just not a particularly high-profile defense procurement agency, right? So I don't know what kind of procurement resources they've got available to them, and it could just be, and likely was, just government folks doing what they thought made sense without having the legal resources or an acquisition training that they really ought to have had.
Well, if a commissary runs out of fruits and vegetables, the customers go bananas. Procurement attorney Zach Prince is a partner at Haynes Boone. As always, thanks so much.
Thanks for having me, Tom.
And we'll post this interview at federalnewsnetwork.com/Federal Drive. Hear the Federal Drive on demand. Subscribe wherever you get your podcasts.